Okay, let's pretend you're in the middle of a lawsuit. Your case has been filed in the circuit court and you are the plaintiff. At some point in time, your attorney may suggest sending an offer of settlement. And you'll say, what is that? And why would we want to send the defendants an offer of settlement? This video will explain what an offer of settlement is and how they work. I will explore some strategies that may help reduce your risk and increase your recovery by using an offer of settlement. But before I dive in, let me say that the offer of settlement laws and procedures are very complex and have undergone numerous changes since they were first created. This video is a simple overview of the offer of settlement procedure, but every case is unique and there are lots of variables that affect each offer. But this video should help give you a basic foundation of how you can use them in a personal injury case. Most people have heard that in England, the loser of a lawsuit has to pay the winner's attorney's fees. In Florida, we have a similar law that says if a party offers to settle the case with the other side and the other side rejects the offer and you go to trial and win by more than 25% of your offer, then as a penalty to the side who made you go all the way to trial, they may have to pay your attorney's fees on top of your award. This sounds simple enough, but let me tell you, it is very complicated. There's a lot of strategy that goes into deciding how much to make an offer for, when to make it, and for how much. But first, I'm going to talk briefly about the mechanics of offers of settlements. The rules say that the plaintiff can't make an offer immediately. You have to wait at least 90 days in order to give the defendant time to evaluate your case. But the defendant can send you an offer of settlement as quickly as 45 days after suit is filed. Also, just so you know, you can't make an offer of settlement within 45 days before a trial starts. All offers of settlement are good for 30 days. So when we send one to a defendant, they have 30 days to decide if they want to accept it. And if one is sent to you, you have 30 days to decide if you want to accept it as well. Also, if you send an offer of settlement, you can withdraw it before the defense accepts it or before the 30 days expires. But if you withdraw the offer, then it has no effect and you can't recover attorney's fees. Now, let me give you two different examples of offers of settlement. The first example is when you make an offer to the defense to settle your case, and the second example is when the defense makes an offer to you. So with the first example, let's say that you offer to settle with a defendant for $75,000. The offer expires and you go to trial and win. The jury awards you $100,000. So in this case, you're entitled to additional fees and costs from the day you made this offer. This is because you offered to settle for much less, by 25%, than you ultimately were awarded a nice verdict. So therefore, the court will penalize the defendant for not settling your case when they should have. The penalty will be the value of your attorney's fees from the date you made the offer to them. The theory is that since you made what turned out to be a very reasonable offer to settle the case, and since the judgment is 25% higher than your offer, the defendant should be punished for making you go through all the effort and expense of trying the case when they should have paid you when you made the offer. Now here's the second example. Instead of you offering to settle the case, the defendant offers to settle the case with you. They offer you $100,000 as their offer of settlement. However, you turn down their $100,000 offer, you go to trial, and at trial, the jury awards in favor of you, but the verdict is only $50,000. Since you recovered less than their offer to you by 25%, then you will be penalized for not accepting their $100,000 offer, and now you will be required to pay their attorney's fees and costs from the date their offer was made to you. Now let's discuss strategy when there's more than one defendant. For example, let's say you're in a car accident. We file suit against the driver of the car and against the owner of the car. Since we have two defendants, let's look at what we need to consider when making an offer of settlement in your case. Let's say our goal is to settle your case for $100,000. We could offer to settle against one of the defendants, let's say the driver of the car, for $100,000, and state in our settlement offer that if they agree to settle for $100,000, we will drop the case against the other defendant, the owner of the car. If the defense accepts the offer, then the case is over. If they don't accept this offer, then in order for us to trigger the attorney's fees, we will need to end up with a judgment against the driver for $125,000 or more. Now let's look at a different strategy. We want to settle the case for $100,000, and we could offer to settle against each defendant for $50,000. This could have three different outcomes. One, they agree and pay $50,000 each. Or two, they don't agree to settle any of the cases and we go to trial. Or three, they accept one offer and settle for one of the defendants for $50,000 and we go to trial against the other defendant with $50,000 in our pockets. And here's another strategy to consider. Let's say we are sure that we can't settle your case and we know that we will have to go all the way to trial. Since we know your case won't settle for whatever reason, we may want to consider sending an offer to settle the case against just one of the defendants for a low amount. Let it expire. Then the idea behind this strategy is that the insurance company won't accept a low offer to one defendant and still have to litigate for the other defendant since they represent two defendants and your offer is only against one of them. For example, suppose you still want the $100,000, but you offer to settle with the defendant car owner for only $20,000. If they accept it, then you go to trial only against the driver and you have $20,000 in your pocket. And if they don't accept it, you only have to recover $25,000 to trigger your attorney's fees. So in this example, if you made a low offer to one of the defendants and the final judgment was what you expected, $100,000, you would be entitled to recover the reasonable value of your attorney's fees and costs from the date the offer of settlement was made. So these are just a few examples of some strategies for making an offer of settlement. Now let me share with you what ultimately happens at the end of a trial. At the end of a trial, the jury fills out a verdict form. This is basically a paper that says who proved what in your trial. In a car accident case, a verdict will usually have the following questions for the jury to answer. 1. Was the defendant negligent? Yes or no? 2. Were you negligent? Yes or no? 3. What percentage of negligence do they attribute to the defendant and to you? 4. What are your past medical bills and past lost wages? 5. What are your future medical bills and future lost wages? 6. Did you suffer a permanent injury? Yes or no? And 7. If you did suffer a permanent injury, what is your past and future pain and suffering? Now, these are simplified questions on a verdict form. If the trial goes great, then all of the answers will be favorable to you. But in many cases, the jury may not find that you suffered a permanent injury, and therefore they will not award you any pain and suffering. And in many cases, when they don't find a permanent injury, they also won't award any future lost wages or future medical bills. So when the numbers are added up, the jury verdict is given to the judge, who then enters a judgment. Now, what is important about your judgment is that it is the judgment that determines if you have triggered or won or lost an offer of settlement. And before a judge signs a judgment, he may have to add some things to the judgment, such as court costs, and he may have to deduct such things from the judgment, such as what was paid by your PIP carrier or write-offs from your medical bills. My point is this. When it comes time to select the number that you want to offer in your offer of settlement, you want to be low enough that your judgment exceeds it by 25%, and yet high enough that if they accept it, you're going to be compensated fairly for your injuries and damages. 99% of all personal injury cases settle. Since the insurance companies have the money, they can pick and choose which cases they want to try and which ones they want to settle. So if your case is one that they think they can win, they probably won't offer much to settle your case. So by making a low offer of settlement against them, this increases your recovery when you do win. Sometimes it's the only leverage we have on a tough case when the insurance company forces us to go all the way through a trial. Also, you can make more than one offer of settlement. So if we go to mediation and they won't offer fair money to settle your case, and we believe they are locked into a low number, then we can make an offer slightly above their highest number and hope they don't accept it. Or if you think they're bluffing at mediation, we can make an offer slightly higher than your last offer to settle the case, and they may change their minds and accept your offer. Let's suppose you're in a situation where the insurance company won't make a reasonable offer to settle your case. Maybe they just don't think a jury will award much money for you, or they think that the jury will find you don't have a permanent injury. For whatever reason, you can't get your case settled, and now you know you're going to have to go to trial. Here's a strategy that may improve your recovery and may give you a little extra protection at trial. Calculate what your judgment would be if the jury only gave you your past lost wages and past medical bills. In some really tough cases, like when a jury does not like a case, but they still like the injured victim, they will often compromise the verdict and give the plaintiff some of their damages, but not all of them. So it's common to see a verdict where they award past medical bills and past lost wages, but they don't award anything else. In this situation, if you had sent an offer of settlement for 75% of your past medical bills and lost wages, then even in a tough trial, you have a better chance of recovering some of your attorney's fees. I hope you found this information helpful, and I can tell you that even lawyers and judges find the offer of settlement rule confusing. Hopefully I've shed a little more light to help you make some good strategy decisions if you need to consider making an offer of settlement in your case. Thank you for watching my video.